Hi, good evening, everyone, and thanks so much again for joining us. This is the first event that the Biodiversity Law Centre has hosted around legislation that's in the pipeline. We hope to do more of these in future, so certainly if you have feedback for us after the event, we would greatly welcome that. So we are the Biodiversity Law Centre. I'm Kate Handy, the Executive Director, and I'm joined this evening by my colleague Nina Brody, who will be taking us through some of the key elements of this biodiversity bill. Um, it is a pressing time for biodiversity. I don't think anyone here can dispute that. And it's certainly a time of a new political dispensation, new people in government. And the opportunity is really here to make sure that we put robust biodiversity legislation in place so that we can secure our biodiversity in South Africa going forward. The session is being recorded, so I hope that is all right with everyone. Please, if you do have a problem, let us know, but we will be recording it because there's some people that can't attend and would like to actually see what is said. This is really meant to be as well an immersive and interactive discussion. I know we only have an hour, and it's really great that people are joining us at the crunch time in the evening, but we encourage you to please put your questions in the chat. It will enable us to deal with them as efficiently as possible. And what we plan to do is take you through some of the key elements of the bill, some of the things we think you ought to be aware of or that we think should be highlighted, some of our own insights, and then really just open the floor up to questions that you may have, where we can debate it as a group, or where you would like the Biodiversity Law Centre to weigh in on our particular views. So I think that is enough said by way of introduction. I'm going to hand over to Nina.
Thanks so much, Kate, and good evening, everybody. And we really are grateful that you've all made the time to join us. So I'm going to try and spend as little time as possible dealing with a bill that is enormously complex. So we do anticipate that you're going to have a lot of questions. So please keep them coming. We're both keeping an eye on the chat, and we'll try and pick up things as we go, as far as possible. So the first, where we need to begin is the purpose of biodiversity legislation. So any piece of legislation, any statute that is promulgated by Parliament has to have a purpose, and that purpose always has to start with the Constitution. In our case, we are looking at Section 24B of the Constitution, which is one of the paragraphs relating to the environmental right. So the overarching thing that any biodiversity legislation has to achieve is to protect biodiversity. And that is because Section 24B provides that everyone has the right to have the environment protected for the benefit of present and future generations through legislative measures that do a couple of things. So if you replace the word environment there with biodiversity as one of its components, that is the big headline news in terms of what this bill needs to achieve. And one of the first things that we've done is we've asked ourselves in reading the bill whether it in fact does that. So in terms of the three components that have to be covered by the bill in achieving the protection of biodiversity, the first is that measures need to be put in place that prevent harm to biodiversity. And that comes from the language of Section 24B1, which says that the measures have to prevent pollution and ecological degradation. Practically speaking, in the context of biodiversity, ecological degradation could include things like the introduction of alien species that break down or that take up habitat of endemic species. It could be something like rhino horn trade that is unregulated, leading to poaching. And those would sort of be very obvious examples, but there are many more. The second thing that has to happen is that measures need to be in place to promote conservation of biodiversity and its components, including ensuring the well-being of animals and embedding conservation, supporting cultural, traditional, and spiritual practices. And this all comes from the constitutional obligation on the state and on the legislature to promote conservation. Promoting conservation in the context of biodiversity is an enormously complicated task, and the measures need to do a huge number of things for individual organisms, organisms living in community, for species well-being, for species survival. And this includes the kinds of things that relate to protections for endangered species. It relates to things like ensuring that the approach to conservation it moves away from things like fortress conservation, where parks are set aside and we live our lives somewhere else, and that conservation is mainstreamed through everything we do. And the final component of the constitutional obligation is that biodiversity legislation has to put measures in place to secure and safeguard the long-term continuation and integrity of biodiversity in all its complexity and variation. And this comes from the constitutional obligation to secure ecologically sustainable development and use of natural resources. I said, I see I've put in natural resources. That must be a Freudian slip. So when we are reading this bill, the first question that we have to ask is, does it achieve these things? Does it prevent harm, promote conservation, and secure ecological sustainability of our biodiversity? The other thing that we need to ask is, has it met the policy objectives that were set out in the white paper on conservation and sustainable use, which was published last year, and which is the main rationale, or should be the main rationale, for any kind of legislative reform that takes place at this time. Now, the white paper has 4 goals and 2 enablers. And the goals, without reading their full titles, concern enhanced biodiversity conservation, sustainable use, equitable access and benefit sharing, and then transformed biodiversity conservation and sustainable use. The 2 enablers are that biodiversity is integrated, mainstreamed, and effective. And the second is that there are enhanced means of implementation. And this leads us to the third question that we need to ask ourselves, which is, does this bill work? Can it be implemented? And in this regard, one of the reasons that the Department of Forestry Fisheries and the Environment, so the DFFE, has given in its explanatory memo and Gazette notice is that they were experiencing implementation difficulties with the current legislation, which is the National Environmental Management Biodiversity Act, or NEMBA.
Sorry, Nina. Can I just ask? I think you're meant to be on the next slide, but it hasn't moved on.
I'm not. No, I'm
okay.
not.
All right.
We haven't moved on. And I see, yes, no. There are very few slides, and I haven't put everything on the slides, so worry not. So much for the objectives behind the bill. So in terms of how the bill is structured, there are 9 chapters. And as with all pieces of legislation, the first chapter deals with interpretation, objectives, and application. We're not going to spend a huge amount of time on that, if any. We have some lawyerly comments on that, but more or less that chapter we have few massive thematic issues with. The second chapter deals with the South African National Biodiversity Institute, or SANBI. It is largely a repetition of what appears in NEMBA. There are some modifications, and we have been told by the DFFE that that is after consultation with SANBI, and it's really to align with what is actually happening in the operations and workings of SANBI. Chapter 3 deals with National Botanical Gardens and National Zoological Gardens. It is largely a repetition of provisions that sat in NEMBA around SANBI's control of National Botanical Gardens, but National Zoological Gardens have been introduced. And we understand this to be because SANBI, in fact, manages the Pretoria Zoo, and also it manages the Mokopane Conservation Centre, although that is not provided for in the bill. We do have some concerns about the way in which zoos have been included in the bill, and if we have time, we'll go into that. The three chapters that for us create the biggest problems are chapters 4, 5, and 6. The first deals with biodiversity planning, which was something that was provided for in NEMBA, but there is an attempt at changing this, which in our view causes some confusion, and it also rather than mainstreaming biodiversity through other planning instruments, such as municipal planning and agricultural planning and so on and so forth, it creates a sort of weird circularity where biodiversity plans have to incorporate the objectives and the considerations of other plans, while those plans have to incorporate biodiversity plans. And in our analysis, this doesn't promote that objective from the white paper of biodiversity mainstreaming, and it also makes it very, very difficult to actually give meaning to what is done through biodiversity planning. Chapter 5, which deals with ecosystems and species, we'll come to shortly, and that together with the alien and invasive species and GMO chapters are the ones that have changed the most and which we feel have fail in terms of an effective implementation mechanism. Chapter 7, which deals with access to Indigenous biological resources and Indigenous knowledge, bioprospecting and benefit sharing, is, we think, the big success of the bill. South Africa is signatory to the Nagoya Protocol, which is a protocol to the Convention on Biodiversity. It deals with these matters. NEMBA was outdated, and Chapter 7 of the bill, in our view, updates NEMBA and it aligns it with the international position. And there are many, many benefits to that, including ensuring proper, free, prior, informed consent of communities who are affected by this. Chapter 8 deals with issuing of permits and emergency interventions, and I'll come to that in a minute. And then Chapter 9 deals with various matters, including the ability of the minister to issue regulations, which we'll discuss in a moment. So we see the bill as containing a number of good things, quite a number of bad things, and overwhelming number of baffling things. So first, the good. Excuse me. The intention behind the bill is undoubtedly a good one. There is an intention to mainstream animal well-being, cultural rights, and concepts such as seascapes and landscapes into the bill. This is consonant with the white paper. This is consonant with the direction in which the world is moving in the biodiversity space. But the problem with the way that this is being done is that we're doubtful that those purposes are in fact achieved. So intention good, but implementation may not happen. There is an attempt to strengthen controls over illegal trade in biodiversity, with particular regard to CITES, which is the Convention on the International Trade in Endangered Species. This has potentially been well done, although there's some confusing provisions that are a result of the DFFE, we understand, trying to be responsive to priorities by SAPs and other enforcement bodies in fighting wildlife crime and plant crime as well. There's an attempt to align with the actual role of SANBI. We've mentioned that already. And there is, and we feel that full effect is being given to the Nagoya Protocol. So so much for the good. In terms of the bad, we are a little bit concerned about some of the background motivation for a whole-scale revision of NEMBA rather than updating it and aligning it to the white paper through amendments. And our concerns are drawn both from the way in which the bill is structured, but also from the following rather troubling statement that appears at somewhere in the beginning of the socioeconomic impact assessment form, which accompanies the bill and is the form that has to go with the bill to the presidency. And it reads as follows. The Biodiversity Economy Lab that was hosted in 2016 highlighted one of the key drivers preventing or hampering growth of and opportunities in the biodiversity economy relates to excessive permits and a legislative framework that is not conducive for economic growth. It was further highlighted that one of the main constraints of NEMBA is the fact that it focuses on biodiversity protection and conservation, and although sustainable use is reflected in Section 2 of NEMBA as one of its objectives, it does not contain provisions that promote sustainable use. So if you recall that slide, the primary constitutional mandate behind legislation dealing with biodiversity is protection, and conservation is a key part of that. Moreover, an economic use, in our view, is something that is very, very low down on this list of priorities for legislation, if it is there at all. So we question this motivation, and we question the manner in which that may have been pulled through in some of the provisions of the Act. Well-being, duty of care, seascapes and landscapes objectives are not met. This is very clear in the planning chapter, which retains the National Biodiversity Framework, which we don't have any problem with, but then incorporates spatial biodiversity plans in a way that does not seem to have any direct correlation with the concepts of seascapes and landscapes. Similarly, in the context of the chapter dealing with species and ecosystems, there seems to be an uneven and inadequate obligation to provide for the well-being of animals, and also to provide for a duty of care in respect of all engagement with biodiversity. Excuse me. Linked to this, the manner in which Chapter 5 has been drafted, as well as Chapter 6. So those are the chapters dealing with species, ecosystems, and alien and invasive species. The clarity of obligations to prevent harm and promote conservation have been removed because these are now being left to regulation. So in the body of the Act or the bill itself, there is very little that tells us what we may or may not do. Very, very problematically for us, there is a weakened mechanism for public participation and equitable access. The most recent amendments to NEMBA confirmed that a very robust public participation process, as well as an intergovernmental consultation process, had to be followed by all the decision makers involved in NEMBA. Those public consultation processes have always been part of NEMBA, and they are extensive. They also speak to the principles in the National Environmental Management Act about people being involved in decisions about their own environment, and also the constitutional manner in which the courts have interpreted the relationship between people, conservation, and biodiversity. This is something of enormous concern to us. We have no doubt that the DFFE has tried to limit the scope of public consultation because it is enormously cumbersome, very costly, and it will not be appropriate for every single circumstance. They have indicated that what remains in the bill is a minimum standard, but in our experience, it is usually a good idea to put in much more than the minimum standard in legislation, particularly over issues that may be contentious, and biodiversity is one of those. And then we have a concern that the relegation of the detail to the regulations, which are to be published by the minister at some future date, is a way of is an instance of executive overreach. The legislature is designed in our constitution as being the home of democracy and the place where we can all voice our views. And they are tasked with coming up with the sort of firm boundaries in terms of what we can and cannot do in a particular space. What has happened here is that the bill tries to create a framework within which the executive can decide where the boundaries are. And in our view, this is potential executive overreach, particularly since environmental decision-making is already under a framework piece of legislation being the National Environmental Management Act. So that is a little bit of a technical concern we have, but it's an important one. Now the baffling. And this is where we really think that the DFFE may need to go back to the drawing board. And this is where in our own comments we have placed our emphasis. The first issue is that the planning instruments in the bill create circularity. And this particularly happens in relation to biodiversity management plans and all sorts of other planning instruments that are not biodiversity planning instruments. So, for example, planning instruments used by the municipality, other planning instruments that are used under NEMA, and so on and so forth. The way this happens is that the clause that deals with biodiversity management plans says that they have to have regard to all these other plans. And then there is a coordination clause in clause 39 that says that all those plans have to incorporate various biodiversity planning tools. So we see that as an issue. And in our view, what ought to be happening is that the biodiversity planning tools feed into other spatial planning tools so that they can be responsive to what is happening with our biodiversity, and biodiversity can in fact be mainstreamed, as is argued or as is promoted by the white paper. The problems in chapter 5 and 6 are very similar. What both of these chapters do is they set out in quite broad terms that the minister needs to list species or ecosystems that are threatened in the case of chapter 5. And then it has some other categories, including species or ecosystems that need particular attention because of cultural use, and species or ecosystems that need particular attention due to because of a need for heightened consideration for their well-being. Then what happens in terms of the species and ecosystems chapter is that within the same paragraph, the minister must also provide in her notice that lists these species and ecosystems, the conditions and prohibitions that go along with those species and ecosystems. The same structure happens with alien and invasive species, particularly invasive species. And we understand that this was done because previously there was a definition of restricted activities. So if a species was listed as threatened, there would be an automatic consequence that there were not an, sorry, I'm distracted by Paddy saying there are too many maize and not enough mus, and that isn't exactly part of our problem. But what has happened now is that absolutely everything is left to regulation. One cannot pick up the bill and understand what you can do, what you can't do. There are no restricted activities in place. There is nothing that shows you that there is an automatic consequence if something sits on a list. And so this leaves one a little bit at a loss to go and find whichever notices or regulations there are governing your particular species that you are engaging with. That is very, very problematic in terms of conservation objectives. It is enormously problematic in terms of meeting our obligations in terms of international trade and wildlife and so on and so forth. But it is also, to call the DFFE's own bluff, very, very, very problematic in terms of wanting to engage in economic activity, which relates to any of these species. So I'm jumping over that slightly because it is there's a lot of devil in the detail. So please feel free to ask questions where we can elaborate on that. And then our final moment of confusion is that at the end of the white paper, an implementation plan is mooted. So it more or less says that we, the department, are going to have a consultative process where we're going to set up a implementation plan to look at how to put the white paper into practice. And one of the steps in that plan is to analyze the existing legislation, which would include NEMBA, to see where it has gaps, and then to consider amendment. So we are slightly puzzled that this bill has now been published. We are not aware of a roadshow. We are not aware that this implementation plan has been rolled out. And one of the things that we are asking for is that the department does what it said it would do and have a plan. So we understand and sympathize with the department in having implementation difficulties. The biodiversity is hard to manage. There are a lot of exceptions. There are a lot of competing interests. But as far as we are aware, no clear report setting out the implementation difficulties has been published. It must exist somewhere in the department, and we would call upon them to publish this so that we can see what the problems are, and potentially people can then comment meaningfully and provide some solutions. We certainly would urge them to follow the implementation plan, which sits in Chapter 8 of the white paper, and to do so without much delay, noting that we've got the next conference of parties for the Convention on Biodiversity later this year. And then we acknowledge that there are some amendments that are immediately necessary, such as alignment of NEMBA with the Nagoya Protocol, and we do not see too much difficulty in that being put into an amendment bill that is put through Parliament or introduced into Parliament as soon as possible. And that is really us in a nutshell. I've spoken longer than intended, and we leave it to your questions. Thank you very much.
Thanks, Nina. A great introduction to the bill and some of our thoughts on it. I see there are a few comments and questions in the chat. The first one is from Adrian, who says that, however, bioprospecting is dangerous due to lack of knowledge and education, especially from PDIs, will lead to exploitation, and shouldn't protection occur before bioprospecting is allowed? And I think, just to briefly address that question, that certainly, I mean, protection is what we're saying is the primacy of this legislation. It must foreground protection of South Africa's biodiversity, but also there is some consolation given in that the provisions around bioprospecting, and particularly access and benefit sharing, have been significantly built up. And there is now a requirement to not only secure a bioprospecting permit for commercial exploitation, but actually for the discovery phase of bioprospecting as well. And there's quite detailed provisions around the prior informed consent and the access agreement that needs to be concluded between the minister and somebody wishing to bioprospect, which creates an additional safeguard around the activity. So I do think that there have been some positive developments in the context of bioprospecting. I see, Will, you have your hand up. Do you want to pose your question to the group?
Yes, please, if you don't mind. I see two really big omissions. I know you guys glossed over the introduction or interpretations, objectives, and applications. I really would like to urge the whole constituency that's listening here is that we have to pay attention to that. And if we take a step back and look at the Constitution when it was accepted in '96, a mere 2 years later, we had the Water Act, which recognized the nationalization of water. Sometime just after that, the Mineral Act came into being, and the nationalization of our mineral resources came into being. That was challenged in various applications through various courts, eventually settled in the Constitutional Court. Why 30 years later, almost 30 years later, have we not accepted what the Constitution says about our biological assets being a nationalized resource? And I think we need to be bold and assert that. because the confusion that comes in, and you've highlighted it in terms of the sort of flick-flacks that are being done through regulations and taking out the prerequisites in the Act to disappear into regulations yet to be promulgated, comes into that because the government consistently wants to transfer public goods to private interests through a permitting system. And I think if we don't pay attention to that, we're going to run into the same problems that the current legislation have realized in practical terms. And related to that is the other void, and that is public accountability. If a permit is issued, it is the transference of a public good into a private interest, and that must be published in an open register so that we know where our public goods are going. And the governments have, that's when I say governments in plural, I mean the provincial governments, together with the national governments, have played this game where they can hide their accountability of managing our resources through hidden confidentiality issued permits. And I think the bill should reflect that. So I would strongly appeal to this constituency to pay attention to that.
So, Kate, I don't know if I should just respond on part of that. I think, Bill, thank you very much. If we can just ask if people can, we're asking people to put comments in the chat so we can respond to things quickly. But I'm assuming that in terms of the nationalization of water and minerals, you are referring to placing them under the trusteeship or custodianship of the state. Both NEMBA and the bill have an equivalent clause. In our submissions, we have recommended specific language around that clause to make it clear. It has been slightly truncated in the current bill from the language of NEMBA, but it is there. So notionally, the manner in which the relationship between permits and biodiversity work should be the same as the manner in which mineral rights, prospecting rights, exploration rights, and so on and so forth work in relation to minerals, and the same way that water rights work in relation to water. And in that regard, I think you make a very, very good point that water rights are supposed to be publicly accessible, water use licenses. There is a long-standing fight over having the mining cadastre actually operationalized. Those rights are supposed to be public, and if one does follow through, it's a very good point that the permits which enable use of biodiversity resources should also be public. So that is certainly something that we should consider.
Nina, if I may just add to that, sorry to interrupt here, and it's the last thing I need to add, is when you apply for a mining license, there's a public process that is scrutinized by interested and affected parties. The same with regards water use. So if you want to build a dam or extract, you have to go through a public process. The same does not apply to access to biodiversity asset. In fact, it is strictly secret. And I have tried for 15 years to understand why the secrecy is in place. And government departments weaponize this aspect. And until we become accountable to it, it will continue. And maybe that's the reason I'm deeply suspicious why these controls in the Act have been watered down in the way they have been. Because I suppose that it wants to feed into that abuse of the permitting systems.
Yeah, I think, Bill, you make an excellent point there. It is the lack of transparency is really a pervasive issue across the sector. And I think, it's even more alarming that the public consultation or public participation and consultation provisions have been so significantly watered down, because, that was at least one mechanism in terms of which an interested party could claim that there was a right to be heard, a right to participate in decision making, certainly from an administrative justice perspective, if not overtly referred to in the Act. But now we see even more truncated provisions with a very basic notice and comment procedure, and that doesn't even relate to the individual permit applications. And that's only in relation to the decisions around species listing and the like. So I think it's definitely something that in our comments we ought to address, is just the transparency with which permits are issued. I see we've got quite a few questions in the chat, so I'm going to delve into them. Paddy, your question around where issues have been devolved from the Act to the regulations, would the clause in NEMBA remain in effect until the new regs are promulgated? It's quite a difficult one, and we haven't gotten to the bottom of it, because actually there is a clause in the bill which proposes to keep any regulation or notice that's made in terms of NEMBA in effect until such point as it's repealed. But that's quite difficult when you've got a fundamentally different system in terms of which the listing and regulation of activities in relation to biodiversity is actually managed. So it's unclear to us, and certainly a comment that we need to make in relation to the transitional provisions is that it's not clear how to transition from one system where you've got one particular kind of listing to another system which is fundamentally different. But I think that's a question that we need to raise. And Nina, I am going to pass Judy's question on to you. Judy makes the very valid comment that if you read the bill, you get the impression that threats to biodiversity are alien and invasive species, GMOs, export of indigenous biological resources for bioprospecting, and that the impacts of development, pollution, climate change are not discussed. Are they covered elsewhere? And I mean, this is, Judy, you also raise an excellent point. This is something that we have ourselves grappled with, but I'll leave it to Nina to answer this one.
No is the short answer. Well, yes and no. So the impact of development, pollution, climate change ought to, so the Biodiversity Bill is supposed to be a specific environmental management act, and there are a number of those. So theoretically, the impact of development is meant to be dealt with through NEMA and the EIA regulations. Pollution should be dealt with by different acts, including the Air Quality Act, the Waste Act, and so on and so forth. And then climate change should be dealt with by the Climate Change Bill, which is sitting on the president's desk waiting for assent. That said, we are concerned that in the planning section of this particular bill, there is no mention of two key planning instruments, which are the planning instruments contemplated under the Climate Change Bill. That one could excuse just insofar as it hasn't actually been assented to, perhaps. But the other is that the planning instruments under the Marine Spatial Planning Act have not been included. And that is significant because those deal with the zones in the ocean where different activities can and cannot happen. So where pollutants may or may not be heightened, and where biodiversity needs particular protection. So that is one omission. The other big issue is that in the chapter that deals with ecosystems and species, the bases on which a threat can be recognized is not clear, and it is left wide open in terms of regulation. And there is no guidance that says that the regulation, when it is promulgated by the minister, has to consider X, Y, and Z. So that is, and Paddy made the comment that there are too many mays and not enough musts. The absence of criteria to guide the minister in making his or her decision is an enormous problem. And this comment of yours, Judy, is one of the places where that comes in. What I would say, though, that the trick with all of this environmental legislation is to see how it connects or doesn't connect. And one of the most obvious things about the bill is that it seems to contemplate in places interrelationships with other pieces of legislation. But what is missing from the end of the bill is a section that says, and these things have to be inserted into the National Environmental Waste Act or the Air Quality Act or whatever it is. So it sort of doesn't look at the scheme as a whole. And that is of concern. I hope that answers that question.
Thank you, Nina. Yes, the cross-pollination is definitely an issue that needs to be addressed if this is going to be workable across the various CEMAs and other relevant legislation. Joe, I see you asked a question about what would be the practical mechanism for nationalizing biodiversity. I think Nina addressed this in her answer to Bull around the notion of holding biodiversity in trust. So unless you unless you want to sort of discuss this further, I'm going to rather say let's take that offline. I do see that there are some other questions that have come through. Another one from Enrico. Is overfishing considered as harming biodiversity? And in such a case, what would the consequences be, as that management is controlled by the government itself? Nina, do you want to tackle this or?
I'll tackle it. I just want to go back to the constitutional bit to explain how we see it. I think the short answer would be yes. But that's certainly in our view. And that is because it would be a use of part of the ecosystem that is not ecologically sustainable. And so whether one wanted to put it in the first bullet or in the last bullet, it would certainly be a problem. In terms of what we said about the interrelationship between legislation, there is a difficulty here that there is insufficient connection between the Marine Living Resources Act, under which permits for fishing are provided, and under NEMBA. And we are aware that the Marine Living Resources Act is also currently under review at the moment, so keep your eye on that one. But it is also curiously not listed as a CEMA under the National Environmental Management Act. So when that one comes around for comment, everyone can potentially bring that up as an issue. Having said that, the environmental management principles should apply. The principles of environmental management decision making in NEMA should apply. And we would argue that biodiversity legislation should be read alongside the MLRA when it comes to marine ecosystems. So yes, that is certainly a problem and a legislative gap. Whether or not that is something that can be cured in this particular bill, we're not sure. And there are many things that we are still asking questions about. But that is certainly something where potentially the legislation speaking to each other would be of benefit.
Thanks, Nina. I see Paddy has raised an interesting question around having an issue that the foundation of biodiversity is habitat protection, and that this bill does not seem to address the cumulative impacts issue, which is fundamental to sustainable natural biodiversity. And I think it's really important because we're seeing death by 1,000 cuts in the context of our biodiversity. We're seeing authorizations granted for developments that erode biodiversity, and it's just not getting any better. In the absence of any tools being used like strategic environmental assessments, we're seeing, even areas like the West Coast where the devastation is pervasive, with mining applications being granted there and biodiversity being destroyed. I think that the one thing that we've commented on, where there is potential to alleviate this issue, is through the biodiversity planning provisions. It would certainly seem that there's some encouraging language being introduced into the National Biodiversity Framework around the identification of priority areas for conservation, the introduction of the concept of OECMs, which we haven't before seen regulated in our biodiversity legislation. And what we're arguing for is that even the context of the spatial biodiversity plans, that actually effect needs to be given to fine-scale biodiversity planning, and that includes looking at CBA maps and incorporating those in terms of a hierarchy of the biodiversity planning tools, where you have the spatial biodiversity plans, which are informed by the biodiversity management plans, and in turn inform the national biodiversity framework. So you really have this like overlay of areas where impacts on biodiversity are most stressed and where protection is most needed, and that hopefully that then filters through into decision making. So I hope that is answers the question to some extent. But yes, the cumulative impacts issue is a big one. Kirsten notes that there does not seem to be a clear relationship between this bill and the biodiversity economy strategy. Nina, do you want to have a stab at this one?
We think that it probably depends on how you read the bill. In our view, there's a very clear relationship. And it seems like the bill is trying, through an attempt at deregulation, to enable the kind of economic activities that are contemplated in the biodiversity economic strategy. And we have heavily critiqued the biodiversity economic strategy for being out of kilter with the white paper and for unduly emphasizing consumptive use without regard to prevention of harm, conservation, and ecological sustainability. So we do think that there is a very clear relationship, and our concerns about the removal of controls in the primary legislation they derive from an increasing emphasis on exploitation of biodiversity rather than protecting biodiversity. And this is perhaps something we can debate further offline. Kate, I don't know if you've got anything to add to that one.
I think that was a great answer. Thanks, Nina. I see, Bull, you've asked another question about how does government justify issuing themselves or their contractors fishing permits? I don't have the answer to this one. I don't think anyone does. The justification of government is not always apparent. But I think that Nina went some way in addressing the synchronicities between the MLRA and the Biodiversity Act and how we can hopefully see some cross-pollination between those two statutes in the context of biodiversity protection, particularly species that are being overexploited in our marine environment. Okay, Joe, sorry, I don't think we answered your question adequately. I'll go back to it now. So your question was in response to a comment about how we need to be more decisive about biodiversity protection and insert provisions in the bill that nationalize biodiversity. It isn't clear how we could or what this would mean in practical sense. Nina, I'm not sure if you want to address that further.
Yeah, I'm not sure. This may be something that we need to take offline. I'm not entirely sure what is meant by the language of nationalization. When this was raised, technically speaking and from a legal perspective, minerals, water, biodiversity, our coastal zone are not nationalized. They are held in trust. And it's the concept of public trusteeship is unique in this country in the way it is understood. There is another public trust doctrine that operates in the US. It is, basically what it means is that biodiversity doesn't belong to anyone or anything, but it has to be cared for by the state. And the state is required to control activities that may harm on the one hand and to promote activities that will protect on the other. So it's like being a fiduciary or a trusteeship of a trust who has obligations to the beneficiaries, and the people of South Africa are the beneficiaries. In fact, it's not even the people of South Africa, it's everyone. So it could be non-citizens as well. are the beneficiaries of this biodiversity held in trust. That is the construct. In terms of the debate around nationalization, I don't think that's something that we are going to get into during this call. We've got 10 minutes to go and other questions, and it is something that is a very, very, very different conversation, which actually does not have a constitutional basis at the moment. And is something that is certainly not contemplated in the existing legislation or in the bill. So if anyone wants to debate that with us further, you're very welcome to get in touch with us and we'll pick it up. But that's probably not something for today. And then, yeah, Kate, I don't know if you want to answer the last couple of questions.
Yeah, I see we've got a couple more and 10 minutes left, so we're doing well in terms of time. Paddy says that the one oddity I noticed is that the draft seems to have 2 sections with definitions. Makes me think this is 2 separate bills that were cut and paste together. But I think, Paddy, what you're referring to is the section on access and benefit sharing, where it includes, a whole raft of new definitions that aren't included up front in the Act, in the bill rather. I honestly don't know what the rationale is. Sometimes bills do this and it really doesn't appear clear. I mean, why not put everything just up front in the bill? It would make it so much easier to read. So I agree with you. It does look a little bit confusing. And then your comment that the Act seems to pay lip service to scientific-based advice and in part leaves it unnecessary for the advisory bodies. I think this is potentially a debate that we can take offline. I think that, yeah, well, I mean, I do think that the scientific authority, has certain powers and functions, as does SANBI. But perhaps the bill could be clearer on how these findings feed into decision making around permits and all the different permissions and regulations that the minister is then empowered to produce. So perhaps there could actually just be a bit more clarity in terms of how the advice of SANBI actually feeds into decision making and to regulation making. That might not have come through clearly enough in the bill.
If I can just add to that one, I think that one of the things that the bill has done, which is a positive, is that it has made it clear that SANBI, and I mean, it could be still clearer, but it's made it clear that SANBI is the home of the scientific authority, which is required under CITES. And that has been the case, as we understand it, up until now, but it actually puts it in SANBI's functions, which practically is positive because it allows SANBI to put that through as a budget line item. So they're those sort of nitty-gritty things that are, really helpful. One of the things that we are a little bit confused about is I think it's a general section. The bill talks about recognizing bodies in the biodiversity sector, and it isn't clear to us that this includes scientific bodies, that it includes NGOs. It seems to have its origins in a kind of business-focused notion of biodiversity sector. And we would certainly argue that that is a place where it should be expanded to include the NGOs and academic bodies who do an enormous amount of work on the science of it all. And equally, there is a provision that had previously allowed anyone to put forward a biodiversity management plan that has been removed. And once again, we feel that that should be reinserted because that is a space where a lot of scientists were able to contribute positively to the, and make up for areas of expertise where it was lacking in the DFFE because there are only so many people. And there are so many species and so many ecosystems. So there are certainly areas where that could be improved. And I think also something that one might want to give thought to is whether it is necessary to have the best available science standard pulled through into more provisions. It is pulled through on a number, which we think is positive.
Thanks so much, Nina. I see, Joe, we responded to your question. That's great. Kirsten notes that you haven't seen the transitional provisions yet, but would existing lists of threatened ecosystems and species be adopted in terms of the new Act? Kirsten, this is something I sort of tried to address earlier. There is an odd provision in the transitional provisions which says that any regulation or notice published in terms of the Biodiversity Act, which exists when this act takes effect, must be regarded as having been prescribed or published in terms of this act, i.e. the bill. And it's valid until it's repealed. So technically, yes, I do think that this is meant to be a saving provision. But as I highlighted earlier, given that we're looking at an entirely new regulatory framework, I don't know how regulations relating to current listings of threatened ecosystems and threatened species can be adopted and housed comfortably within the parameters of this bill. So while the intention is there to have these saving provisions, I don't know how that's going to operate in terms of the new provisions of the bill. So that's an area of clarity that we're seeking, because it's really not clear. There seem to be a whole bunch of questions now in the chat. Nobuyiselo notes that as a practical and solution-driven person, I see great opportunities to utilize and capitalize on citizen science, such as tertiary students, opportunities to mitigate the legislative loophole, and that AI applications could be reasonably developed to source mass public participation engagement data and generate information that is quantified and qualified to respond. AI options are opportunities to present and answer concerns to governance and verified tools. This would allow mass engagement that highlights public priorities. I think this is an excellent point. It's something that we have definitely thought about, is what is the role of AI in public participation processes? Can we not really expand on what we do currently and use AI to actually generate meaningful interpretations from that data? I think that there's a wealth of opportunities to be exploited there. So that's a very interesting question or comment. Thank you. Judy asks, biodiversity legislation in the UK sets legally binding targets. The legislation talks about species abundance targets and biodiversity net gain. No targets in this bill. So who sets the targets and goals? Nina, do you want to have a stab at that?
Yeah, I think that is an excellent question. I've started having a look at the legislation, which at the moment is actually subject to challenge for the UK not meeting its objectives, its targets. The short answer is it actually isn't anywhere. And one of the difficulties is that, and this is the same problem with NEMBA, and it's not cured by the bill. We are signatories to a whole bunch of biodiversity conventions, and all of them have reporting cycles, and some of them have actions that have to be met, some of them have targets that have to be met. And nowhere in the legislation is there a specific requirement to set targets or meet targets or report on targets in terms of these conventions. And we have made a comment, and maybe we may want to look at expanding on this, that the bill provides for the National Biodiversity Framework, but it doesn't seem to have any way of matching that to the National Biodiversity Action and Strategy Plan that's required under the Convention for Biodiversity, and which is the thing in which our targets would be. So that is something that it's an excellent question and is a weakness of the whole environmental framework as it relates to our international obligations, let alone South Africa determining its own targets beyond, above and beyond obligations. And perhaps we need to look at the manner in which the determinations are addressed in the Climate Change Bill or Act. I'm not quite sure what to call it at the moment, given its status. But that is an excellent question. Thank you.
Thanks, Nina. I see we are at 18:59, but Bull, your hand is up. Can you keep it quick?
Yeah, I just wanted to say it's wrong to suggest that the public trust doctrine indicates that no one owns an asset. The public trust doctrine indicates that the public owns an asset. And it's really foundational. If we're not going to deal with this issue, you're not going to get the permitting issue right. Whatever targets are set or regulations are applied, It is a foundational issue that must get sorted out, and there are mechanisms to deal with public goods. Why should it be any different for biodiversity than for other goods?
Thanks, Boo. Yes, it is a very interesting comment, and I hope that you'll be pulling it through in your own comments on the bill. I'm sure you will be. All right, it is 7 o'clock, and we have kept everyone for the hour we promised. As I said at the beginning, this is the first event that the Biodiversity Law Centre is hosting in terms of explaining some of the legislation that we're seeing coming out of the department. It would be great if those who wanted to give feedback could give us feedback. We welcome it. But otherwise, thanks so much to everyone for joining this evening. It's been a very interesting engagement. We've certainly learned a lot and have some takeaway points for our own comments. So thank you very much, and have a good evening, everyone.
Have a good evening.